A Federal Capital Territory High Court in Abuja has ordered the remand of former Kogi State Governor Yahaya Bello at the Kuje Correctional Centre over allegations of 110 billion naira fraud. Justice Marianne Anene denied Mr. Bello's bail request, ruling it premature and incompetent as the application was filed before his arrest. Bello was initially held by the EFCC but will now remain in Kuje unit until his trial begins on January 29, 2025. Meanwhile, his co-defendants Umar, Oricha and Abdulsalam, Hudu were granted bail of 300 million naira each with 2 sureties. The court also scheduled February 25 and 27 for the continuation of the trial. And now to discuss this, we're joined by a Public Affairs Analyst, Justice Ojienoh. Justice, good afternoon and welcome once again here on the news. Now, let's start by asking what the legal implications of the court ruling that Yahaya Bello's bail application was prematurely incompetent. Since you're a lawyer, I mean, hey, let's understand this, prematurely incompetent.
Okay, what the court, in coming to that ruling, the consideration of the court was that he filed it before a charge was read to him. Because in law, especially in criminal procedure, a case only commences once the charge is read to the criminal defendant. And it is now for either the lawyer to the criminal defendant to jump in and say he's objecting to the charge before the criminal defendant pleads one way or the other, meaning whether he's guilty or not. So the court in this situation said that that he filed it way before the commencement of the criminal proceedings, and because of that, it is incompetent. It is for the lawyer, to Mr. Yahaya Bello, to either agree with that ruling of the court or to appeal the ruling of the court. But in exploring one of these two, he also has an additional option of filing a fresh bail application. So it's any of the 3 options. So once it decides on any of the 3, I most likely actually think that it's going to be the 3rd one, which is filing a fresh bail application, because they will not want to score a victory, an egotistic victory, by saying that, okay, he wants to insist on his own stance, which is that the justice of the High Court was wrong in coming to the decision of overruling their bail application.
Justice, this has gone on for so long, and from the visuals that we can see even on the TV, people are beginning to ask questions regarding the way this situation has been handled. So how could the remand of a former governor of such significant fraud charges affect public perception of governance and also anti-corruption efforts in Nigeria?
Okay, for me, I actually think that the EFCC goofed in not arraigning him before now, whether it's by hook or by crook. They ought to have shown that the Nigerian state actually has law enforcement powers. They have a teeth to bite. So they ought to have arraigned him significantly earlier before now. So when you say that the case has gone on for so long, that's what delayed it. Because in criminal law, we can actually say that his case started not too long ago when the court decided to try him in absentia. And but for that, I think that significantly the case ought to have gone a long way, because if we observe now with respect to this 110 billion charge, the court has actually reserved 4 dates, 2 dates in January and 2 dates in February, in order to see how far the hearing of the cases can go. So long as I'm concerned, the judiciary, with everything that has been presented to me, has not been complicit in any way in prolonging this case. It is usually the usual suspects, which is the prosecution or the investigating parties or the law enforcement agencies, that have allowed this matter to drag for this long. And the perception of the people usually would now be as though I'm reminded by the book of Eric Blair, more popularly known as George Orwell, when he says that all animals are equal, but some are more equal than the others. And that seems to be what is at play here, when the law suddenly has been changed. When all the animals initially thought that all animals were equal, but suddenly a variation has been added to it to mean that some are more equal than the others. And I think that is what is happening now with respect to the way Mr. Yahaya Bello's case has been handled, and unfortunately so.
That was, I think, the third book I read my entire life. Thank you for quoting Animal Farm. But then again, I see you trying to justify the judiciary here, saying it might just be the investigative unit that are making this a deal such a hard one. But let's talk about the co-defendants. Now, this is the judiciary. They've let the co-defendants go on bail, and they've said, hey, Bello cannot. So why? What gives here?
Okay, for me, I actually think that it is very, very possible that after the charge was read, that bail application was filed by the lawyers to the co-defendant. But even in the absence of a formal bail application being filed, I know of the authority of Abiola and Federal Republic of Nigeria. And in that case, the court actually stated that even in a court of record, a lawyer can make an oral application for bail of a defendant. And it is the discretion of the court to choose whether one particular defendant should be granted bail and another should not be granted bail. I'm holding myself from going into the merits of the case. So you and I can actually conjecture, give a conjecture one way or the other, why Mr. Yahaya Bello wasn't granted bail, whilst the others were granted bail. But I know that for a fact, whether or not formal bail applications were filed for the other two defendants, for his co-defendants, it is very, very obvious in law that there is a place in law for after their pleas have been taken, for their lawyers to have applied orally to the court and for the court to consider and grant it. It is all at the discretion of the court, and it is the court that knows what particularly weighed on its mind before it decided in that particular way. So we cannot say that the first one defendant had a particular treatment and the other defendants didn't have that kind of treatment, that the court was biased. The court is a court, especially when it is when it's in bail matters. It's a court of discretion. It's a court of considerations.
All right, Justice, I'm going to ask this now real quick because we're almost out of time. But for a case that's taking so long, so many challenges, first off, to find the defendant was a problem, and then everything that's happened since after then. It's such a high-profile case. So the question is, what challenges would prosecution or defense actually find, as this has been postponed to 2025, early 2025? What challenges should they expect to, well, try to surmount?
Okay, for me, it's my prayer that they don't face any challenges. But the major challenge in high-profile cases is compromise of witnesses. And sometimes the compromise can be as a result of a lot of things going back, a lot of water passing under the bridge, or outright witness intimidation. So that's a serious challenge or a serious consideration. I'm very, very happy that the case has been given an early date in January or February, so that whatever it is that is in the recollection of the witnesses, which is sometimes a challenge too, can actually may not be a big challenge in this case. The witnesses cannot, most likely will not be said to have forgotten their lines or to have had memory issues, memory challenges, and things like that. So the fact that it is short, the challenges are significantly reduced. I pray and I hope that as much as possible, the prosecution is not corrupted. Well, I know of Mr. Kemi Pinheiro, Senior Advocate of Nigeria, is a man of a great pedigree in the legal profession, and maybe all the other witnesses too. I just pray that nothing happens along the lines. I pray that there are no political negotiations. I pray that the Attorney General doesn't use his Section 174 powers to enter a nullity prosecute. And I also pray that in the event that there is a conviction, unlike the way the other two governors were granted a demoralizing you are free to go by the president of the time, I pray that this one too doesn't go that route, so that people, the Nigerian people, or even the people of the world, don't suffer a crisis of confidence when it comes to how we treat persons who are convicted of crimes and criminalities in our country.
Well, Justice, I want to say thank you, and I pray that your prayers are not just the legal kind, but also divine. Thank you very much, Justice.
Thank you.